Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Lorena Evans presenting for us. If you are unfamiliar with the format of this event, first, Lorena is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Lorena will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Lorena to get us started.
Awesome. Thank you, Marissa. Good afternoon, everybody. Like Marissa said, my name is Lorena Evans. I am the supervising attorney with Legal Aid of North Carolina's Second Chance Project. And today I'm here to talk with you all a little bit about criminal record expunctions. Like Marissa said, I am an attorney, but I am not your attorney. And so this presentation is just going to provide you with some legal information about record expunction. And then at the end, I'm more than happy to take questions. Please keep them vague because, like Marissa said, I cannot give you any specific legal advice about your specific circumstances because I'm not your attorney. You are not currently a legal aid client. But I will talk at the end a little bit about how, if after the presentation you're interested to see if you may qualify for legal aid services to apply for possible expunction help, I'll talk a little bit at the end about how you may be able to do that. And we will likely skip over any questions that we feel are too specific to answer. And so for your own protection, just like I said, try to keep the questions as vague as possible, and then I'll answer any that I can. Next. Awesome. So we'll start with just telling you all a little bit about Legal Aid of North Carolina generally. We are a statewide nonprofit law firm, and we provide free legal services for civil matters and criminal expunctions and driver's license restoration to low-income individuals. Our goal is to ensure equal access to justice and to remove legal barriers to economic opportunity. And so we are primarily a civil law firm. The only criminal adjacent matters that we handle are handled by my team, and that is criminal record expunction and driver's license restoration. And so we do not handle like pending criminal matters or anything like that. The only criminal adjacent work we do are those two areas. We will be talking about expunction specifically today, but I will say that if you have a suspended license and are interested to see if we may be able to assist you with that, you can also apply for services, whether it's expunction or driver's license restoration or both. We may be able to help with both of those issues. And so today, the listen and learn that we are here for is the criminal record expunction, but we do have a number of different listen and learns where you can learn more about those legal areas. And so along with this one, we have healthcare power of attorneys, wills, and advance directives, benefits such as Social Security, disability, SNAP, Medicaid, family law, which can encompass simple divorce and custody, and then tenants' rights as well. And so you can sign up for any of those listen and learns on our website, just like many of you I'm sure did to sign up for this one. If you want to know more about those legal areas, or if you think you may have a legal issue that falls into one of those, I would encourage you to sign up for those listen and learns to learn a little bit more about that. So now we'll get into the information that you're all here for today, and that is expunctions. And so start basic, what is an expunction? And so expunction means to permanently remove an offense from the public criminal record. And I say public because as we get into the presentation, I'll talk a little bit about how there are certain entities that can still see expunged records for very specific purposes, I will add, but there are certain entities that can still see and have access to expunged records. And so it is just the removal of an offense or a conviction if someone is eligible from their criminal record. And once an expunction is granted by the court, the public criminal record of that offense and or conviction is destroyed. And so if somebody seeks an expunction, they file the paperwork, it gets reviewed by a judge, and the judge grants that expunction. What that means is the judge is ordering the clerk to delete reference of that offense or conviction from the public record. And so if it is granted by the judge, that is the order to have that offense or conviction removed. Now, there are three primary types of expunction, and so I will start by far with what most, if not everybody who has some kind of criminal record is likely eligible for, and then as I go down, it will kind of, the number of individuals who will be eligible for that type of expunction will dwindle down just because of the law and the requirements that someone has to meet to be eligible for that type of relief. And so by far, what is the most common type of expunction that most everybody who has some kind of criminal record is likely eligible for is the expunction of their dismissed and or not guilty charges. And so, as it might suggest, all charges where someone was found not guilty are eligible to be expunged. For these types of expunctions, if it was a dismissed charge or a not guilty charge, it does not matter what the underlying offense was for. What matters is the disposition. And so if somebody was charged with a simple assault, they were found not guilty, or that simple assault was dismissed, immediately upon that disposition, so immediately upon that disposition being entered, that charge becomes eligible to be expunged from the record. And there's no waiting period beyond, getting the final disposition to that point. So someone could have a court date today where the charge was dismissed and could arguably turn around later that day and file the expunction petition to have that charge removed. And so not guilty charges are eligible, dismissed charges are eligible. Most charges that are dismissed after December 1st, 2021 are being automatically expunged 6 months after that dismissal date. Now, if somebody has dismissed charges that were disposed prior to that date, they are still eligible to be expunged. It just requires that individual to file a petition, which is the form, the Administrative Office of the Court's form, to request the court expunge that dismissed charge. It will not be automatically expunged. And so if somebody has a dismissed charge before that date, you will have to file a petition to seek the expunction. But if somebody was charged with an offense today, and let's say 4 months later it was dismissed, it will be automatically expunged at that point. It will just be 6 months after that disposition date. Now, I see someone may be raising their hand. I don't know, I think Marissa may have covered this, but I don't think you can unmute in this forum. And so if you have a question, I would just implore you to put it in the Q&A, and I'm more than happy to address it at the end. And so even though most dismissals will be automatically expunged after 6 months, that doesn't mean if you wanted to possibly seek the expunction quicker than that you couldn't file the paperwork to get it expunged that way. There are some counties where waiting the 6 months is honestly going to be the quickest way to get the charge expunged, but there are some counties that move a lot quicker. And so if somebody wanted that dismissed charge to be expunged sooner than the 6 months, you could still file the petition and get it expunged that way. And so a lot of people are eligible for this type of relief, and this is by far the most common type of expunction that we see and that we work with. And so we'll move on to the more complicated expunction statutes and what understandably we see that most individuals are concerned about, and that is convictions, aka charges, offenses where somebody was found guilty or pled guilty to them. And so we separate these out into two kind of different categories of convictions. One we call youthful convictions, and the other are just adult convictions. So youthful convictions are most misdemeanor convictions and some class HRI felony convictions that were committed before December 1st, 2019, when that person was 16 or 17 years old at the time that they were to have allegedly committed that offense. And that is just because prior to December 1st, 2019, many 16 and 17-year-olds were being prosecuted in what I'll call adult court, where at the end of that court case, no matter the disposition, those court files were public. And so, which is different compared to juvenile court, the juvenile justice system, where those files are sealed. And so when I run a criminal record search for a person, if they were to have any cases in juvenile court, we wouldn't be able to see them on the public database. And so when North Carolina raised the age to of maturity, I'll put in air quotes, to 18 on December 1st, 2019, what that meant was for most 16 and 17-year-olds after that date, they would likely be prosecuted, adjudicated in juvenile court where the records are sealed. And so as a way to provide some relief to the individuals who were 16 or 17 years old before that date, whose records were public, this expunction statute, which we also refer to as the raise the age statute, provides some relief for most misdemeanor convictions and some class HRI felonies that were committed when someone was 16 or 17 years old before that date that North Carolina raised the age. And so we see that type of relief frequently. And then adult conviction just refers to convictions that occurred when someone was 18 years or older. This is by far the most narrow type of relief. There are many different restrictions to who may or may not be eligible to expunge their adult convictions. And the next slide will kind of get into the meat of that. But this is some misdemeanor and a few felony convictions when someone was 18 years or older at the time of that offense may possibly be eligible for expunction, but there are many different requirements that need to be met depending on the type of expunction, whether it's a misdemeanor or a felony, whether it's multiple misdemeanors or up to 3 felonies. There are a lot of different things that go into determining whether someone is eligible for their convictions, which I won't get into today, but this is one of the main reasons, besides you are not a current client and we are not your attorney, that we're unable to answer any specific questions about possible eligibility because there are so many different moving pieces that we need to know about someone's specific circumstance to be able to even accurately give that information. And so what there is to know is it is possible to expunge convictions, but there are many different restrictions and requirements to be able to do that. Now, what could prevent someone from expunging their convictions? At the very top of the law, the statute that speaks to eligibility for adult convictions, there are a list of alienated offenses that the legislature has said if somebody has a conviction for one of these types of offenses, what that means for them is that they are not eligible to expunge any adult convictions on their record. So it really only takes one conviction of one of these types of offenses to essentially prohibit somebody from expunging any of their adult convictions. Doesn't matter if every other adult conviction may possibly be eligible. Because of that one disqualifying conviction is what we refer to them as. What that means is that the most that that person may be eligible to expunge is going to be any youthful convictions, if they have any of those, and any dismissed or not guilty charges that they have. Now, this section of the statute is complex. It lists a whole different other bunch of statutes where it refers to other offenses. So what we have done for this presentation is essentially taken out the most common ones that we see. There are a couple that I have never seen, and I've been doing this work almost 3 years. And so really we kind of pinpoint and highlight the most common ones for people to show what could disqualify them from expunging their convictions. And so by far the most common ones we see are Class A through G felonies. So these common ones can be common law robbery as a Class G, The sale of drugs are Class Gs. So like selling cocaine is a Class G. Class A1 misdemeanors, this can look like misdemeanor child abuse, or a domestic violence protective order violation is also a Class A1 misdemeanor. Those will disqualify you from expunging any of your adult convictions. Any conviction that requires sex offender registration is disqualifying. Any conviction for an offense where assault is an essential element are also disqualifying. And, the most obvious types of those offenses are where assault is in the name. So assault on a female, simple assault, assault with a deadly weapon. Those types of convictions are also disqualifying. Any felony offense that involves heroin or methamphetamines, also disqualifying. And then possession with intent to sell or deliver cocaine. So PWI is the cocaine. That is disqualifying, which is different from just mere felony possession of cocaine. That is not disqualifying. For cocaine, there usually has to be a further step involved. So whether that's with the intent to sell or deliver, or actually selling and delivering, which differs from the felony offenses involving heroin or methamphetamines. Mere possession of those types of drugs is disqualifying. But mere felony possession is not of cocaine. There needs to be some kind of like further intent to sell, or actually to selling or delivering. And so those are by far the most common types of disqualifiers that we see. And again, what that means is, unfortunately, if somebody has a conviction for one of those types of offenses, that makes them unable to expunge any of their adult convictions. And no matter what other type of relief they're eligible for, whether it's youthful convictions or dismissals or not guilties, by the end, those adult convictions will still remain on the record. So, as I'm sure you're all probably feeling, there's a lot of information. It can get complex very quickly, and that was really just a very brief overview. But the next thing that I like to talk about is kind of the expunction process generally and what that can look like. Because depending on the type of relief that someone is eligible for, or the number of petitions they may be filing, or the counties that they're filing in, this process is not easy, nor is it quick. I've had files that I have worked on for years that are complex. I have had files that are closed within a couple of months. And so it really depends. And, one of the most common questions we get is, how long can this process take? And like any lawyer, I give it depends answer, but it really does, because there are so many moving parts and so many different factors that can account for the time it takes. So all of that to say, most expunctions, depending on the type of relief, follow the same process. And so what usually happens, and I'll speak from, perspective of our team, is the very first thing, that you want to start with is going to be a accurate and complete criminal record. Expunction law is state specific. And so we are pulling a North Carolina criminal record, but when we speak to applicants who are interested in services, we will ask them if they have out of state and or federal convictions or charges, because even though out of state or federal charges and convictions aren't eligible to be expunged, because at least in North Carolina, because it's state law specific, they can affect eligibility in North Carolina for North Carolina charges. And so we want an accurate and complete record in North Carolina and elsewhere if that's applicable, because that is obviously where we start to make sure that we're able to do the analysis correctly and determine the eligibility for the expunction, which is the second step. So depending on what the individual has on their record, that will tell somebody what the extent of their expunction eligibility is. And then at that point, we're seeking out the right petition form depending on the type of relief. And that is because there is a different standard form, Administrative Office of the Courts form, for each type of petition, each type of expunction relief. And so there's one for dismissed charges, there's one for not guilties, there's one for raise to age convictions, there's one for misdemeanor adult convictions, there's one for felony adult convictions. There are a lot of different forms depending on the type of relief. And so you want to make sure you're using the right form. And all of these forms can be found on the nccourts.gov website, which is where all of the standardized forms are kept. And so determining the right form depending on the relief, and then you're completing that form with the required information. And then depending on the type of expunction, there may be additional paperwork that's needed. For example, if someone's seeking the expunction of their adult convictions, what is also required is affidavits from the petitioner, aka the person seeking the relief, and 2 character witnesses to kind of attest to that person's character. And all of the requirements for what is needed is laid out by law in the statute that speaks to that type of relief. And so once that happens, what you will then do is file the petition in the county where that charge occurred. And so this is also where expunction can get complicated fairly quickly, is because petitions have to be filed in the county where the charge occurred, but also in the court division where the charge was adjudicated. So for example, if somebody has Wake and Johnston County charges, let's say they have Wake District and Superior Court charges and Johnston District and Superior Court charges, that at the very least, let's say they're all dismissed charges for the example, is 4 different petitions that that person has to file, because there'll have to be a Wake District for those charges, a Wake Superior, a Johnston District, and a Johnston Superior. So even there, even though in that example, the record only encompasses 2 counties, that's double the paperwork. And so depending on the extent of the relief, there can be many petitions being filed in many different places. There are also time limits depending on how many petitions are being filed. For adult convictions, for dismissals, not guilties, raise the age, you can file those as many times as you need, whenever. There is a set time period to expunge, to seek the expunction of adult convictions, so that is another reason why this can get complicated quickly. So the next step is just follow county-specific procedures for review. What that means is for most dismissals or not guilties, the judges can review and will review those in chambers, meaning there likely isn't going to be a hearing for those types of expunctions. If the petitioner meets the requirements, the judge will often sign and grant it in chambers. For the petition to seek the expunction of convictions, those are the types of expunction petitions that usually the court will schedule for a hearing in front of a judge to talk about the petition and hopefully have the judge grant it at that point. So let's say we get to the end and we receive the granted order back, which the order is essentially just the petition form that was initially filed with the judge's signature on the back, ordering the expunction if it's granted. If somebody gets that back, and what we would do if I was to file a petition for somebody as the attorney, the clerk is likely going to mail me back as the attorney the copy of that order. We are going to check the public criminal record database, which there's 3 in North Carolina. 1 is slowly phasing out. But we are going to search those public databases to essentially make sure that that expunged case number no longer shows up. The goal is that if you get an order that is granted, you search the public databases. If it is gone, that means when you put that file number in, nothing should show up. And that confirms that that expunction order was executed by the clerk and they've removed reference of that expunged case. So that's a very long process, many steps. Hopefully you can see why that can take quite some time. And so like I mentioned, this is the last slide before we kind of get to questions and talk a little bit about how you may reach out for possible assistance. There are a couple of entities that can still see and use expunged records for specific purposes. And so they can't just go in and see them all, whenever they want to for any reason. There are specific purposes in which these entities can see and use expunged records. And just as a blanket statement, all of these entities, the databases that they use are not public. So it's not information that I'm going to be able to see or you'll be able to see unless you work and have a reason to, if you work at one of these places, to see that information. And so prosecutors, aka district attorneys' offices, they can access expunge files for specific purposes, such as calculating somebody's habitual offender status, or sentencing calculations. Specifically, if somebody had an expunged conviction, they can see and can use expunged convictions to calculate sentencing for possible future charges, as well as habitual offender status. So they can use that information for those purposes. Arresting agencies, they can maintain what are called investigative records, and they can maintain these for even dismissed charges. That is just, again, their databases are not public and are not accessible by, myself or you or anybody that doesn't work in that agency, but they can keep and see expunge records. And then for law enforcement, they can also access expunge records for employment purposes or, certification processes. They can also see expunge records for that. And I will say that law enforcement agencies, arresting agencies, like I said, they can see this information mainly because their databases are not public. And so it is possible that if somebody were to have an expunged charge or conviction, and let's say they were to get pulled over by the police may still be able to see that expunged charge or conviction when they are running, let's say, somebody's tags, or looking at your license and running the name in the system as well. And so I just like to make people aware of that as well. But ultimately, expunction is really the process of removing that criminal charge or conviction, if eligible, from the public criminal record, databases, to hopefully, assist with, future opportunities and things like that. But these are, like I said, a couple of entities that can still see those expunged records and use them for specific purposes. So I just like to cover that as well. And so that's the end of the presentation that I have. If you have any questions, please feel free to put them in the chat. Like I said, I don't believe you can unmute, and so we'll only be able to read off the question and answer it that way. Our project page on the Legal Aid website has a lot of good information. Really, what I think is the most important for, possible applicants is the intake schedule that we have there. We are currently in our intake week for the month. And what we have done is designated 1 week most months to open our general intake line, which is the helpline number right there, to open files for anybody who may be interested and who qualifies for services. The week right now is May 5 through 9th. This is when we are opening files. I do know we were having a couple of issues with the line, and so I think they're working on that right now. So hopefully you should be able to get through. If not, I would encourage you to keep calling until the end of the week. We are taking a break in June to do a file review on our project to make sure we know where things are at. And so if you're not able to get through to get a file open this week, the next intake week that we will be open will be July 7th through the 11th. And the way to get through is to call the helpline number, and we have a calendar on our website that hopefully should be updated to the most recent calendar, which shows the weeks in yellow that we are open for our general intake. And so that was a lot of information, a lot of me talking. More than happy now to answer any questions that anyone may have.
Perfect. And we do have a couple questions in the chat. And just to reiterate what Lorena has said, you cannot unmute in this forum. If you have a question, you either need to type it in the Q&A box on Zoom or the comment section on Facebook. First question, if someone's, I guess, record or criminal offense took place in another state, would they need to go to that other state to get that expunged?
Yes, and so essentially, yes. Expunction law is state specific, and so I'm only a North Carolina licensed attorney. I only practice in North Carolina, so I can only speak to North Carolina charges or convictions. And so each state's expunction law varies. And so if that charge happened in a different state, it would be that state's expunction law that you would want to seek out to see if it would be eligible. There are similar legal aid organizations in other states that also do expunction work, I believe, but I don't know if that's widespread in every state. But essentially, yes, if it happened somewhere else, it would be that state that you would need to see if it would be eligible.
Perfect. Are traffic tickets something that can get expunged in North Carolina?
That is a great question, and it depends on the type of traffic violation that it is. And that is just because some traffic can be an infraction level traffic offense, and then other traffic violations can actually be considered misdemeanors or felonies, depending on what it is. And so it depends. But it is possible that some traffic violations can be expunged, depending on the record as a whole.
Would someone need to do a separate form for each charge they're trying to get expunged, or can they put multiple charges on one form?
That's a great question. Multiple charges can and should go on one form, so long as it's in the same county and the same court division. And let's say, for example, if it's a dismissal petition, so long as all of those charges were dismissed, for example, in Wake County District Court, they should all go on that one Wake County District Court dismissal petition, no matter if the case numbers are different.
Gotcha. If someone had charges out of state that have been expunged in the state that they came from, could that stop them from getting an expungement in North Carolina? I think that's what that question is asking.
It should not. I've never seen it, but it would be something that we would want to know if somebody were to become a client, but I don't believe that it would.
If an offense is ineligible for expunction, it doesn't say it's been years since that offense, it doesn't matter the timing about whether or not that would now be expungible.
Yep, that's right. Unfortunately, the law doesn't take into account how long it's been since a conviction or an offense. If it is one of those disqualifying convictions, no matter how long ago it's disqualified and disqualifies them from expunging convictions.
A lot of questions asking about whether or not specific charges can be expunged. As Lorena already stated, those questions are too specific. We cannot tell you whether an exact charge or offense can be expunged in this forum. Someone's asking if they've already had an expunction. Do they have to wait before they can say they have another offense that comes up after that? Do they have to wait a certain amount of time before they can apply for another expunction? Or can they even apply for another expunction?
That is going to depend on the type of expunction relief that person received previously. And so I can't answer that directly. It really would depend on what type of expunction. I would say if it was for dismissed or not guilty charges, you wouldn't have to wait any longer. I'm mainly referring to if it was for a conviction of some sort, then that might depend on when that person got the expunction, for example. But for dismissals or not guilties, those can be filed as many times as needed, whenever someone might need it.
Perfect. Let's see. Someone's asking, in your experience, can someone get all the paperwork if they only had, say, one dismissed misdemeanor charge, to get that expunged in a short period of time? They understand that it might take a long time for the expunction to process, but in terms of getting the paperwork together to file that expunction, can that be done in maybe a week's time?
I think it could be. When I say it could take, the process can take a while, usually it's up to the point in which, someone's filed the paperwork and they're just waiting for the court to review it. I kind of put it this way for anybody that I work with, is that I can, you can move as quickly as you can, drafting the paperwork, getting any of the other documents ready, and getting it filed. Once the paperwork is filed, it's kind of in the court's hands, and that is really when it can vary very, very vastly depending on the county that you're filing in. And so, theoretically, I think it could be done. Someone could get all the paperwork ready in a week. What might take the longest will be waiting for the court to review it.
Does an expunction cost money?
Yes, depending on the type of relief. And so for most not guilty charges and dismissals, somebody can file a petition at no cost. If somebody had a dismissed charge that was dismissed via some kind of deferred prosecution agreement, so most common that we see is somebody's charged with an offense, the prosecution offers, hey, go on probation for X amount of months and comply, or do this anger management course, or, take this class and show, completion of that. Then upon that successful completion, we'll dismiss the case. That is what we refer to as a deferred prosecution dismissal. Those do come with a filing fee of $175. However, there is a indigency form, a petition to proceed as indigent, that someone can file that is essentially them attesting that while they cannot afford to pay for the expunction, it should not prohibit them from moving forward, and the clerk and or the judge can use their discretion as to whether to grant that. And so it's not a guarantee that the fee will be waived if someone files that, but it is an option. And so for most not guilties and dismissals, no. For expunging convictions, there is always a fee. So if it is a youthful conviction under raised to age, that fee is $52.50. And then for adult convictions, it is also $175. But again, somebody can file an indigency form, a petition to proceed as indigent, and request that the court waive the fee. And usually, if somebody's represented by a legal aid organization like us or a pro bono volunteer, that advocate can sign to attest that they are represented. That usually can get the fee waived. And then if somebody receives SSI or SNAP, that can also, but a lot of times the clerk will also want to see an award letter for the food stamps or the award letter for the SSI to support that, to be able to waive it. And so the answer is yes, sometimes no, and the fees can be waived, but it's not guaranteed.
Right. Can a not guilty charge and I guess a guilty charge be put on the same expunction form? Like, can you put not guilties and guilties all on the same petition?
No. The only charges that can go on the same petition is if they are all charges that essentially are eligible to be expunged and have the same disposition, aka the same result. And so all dismissed charges in Wake County District Court can go on one. The not guilties have their own form, but if you have multiple in one county in district court, they can go on the same one. And then the same goes for convictions as well. So if somebody has multiple convictions in Wake County District Court that are eligible, those can all go on the same form. But it needs to be the form in the county, in the court division, where all of those charges are eligible for the same type of relief. So in that example, the not guilty and the guilty would not be on the same form.
Perfect. Where does someone get an expunction petition from?
All of the forms are standardized, meaning it is the same form. It's not like someone can write it up and just submit the piece of paper. It is a standard form that can be found on the nccourts.gov website. They have all of the standard forms for any type of expunction, and all of the other standardized forms that they use are on that website.
I am about to post a link to the NC Courts document site. Can the entire expunction process be completed online? Do you have to actually visit a court?
That is going to depend. As attorneys, we can e-file, meaning that I can sign the document as the attorney and file electronically. I do believe pro se individuals, aka someone that's doing it on their own, unrepresented, can e-file, but in my experience, most individuals will either take it to that courthouse to get it filed, or some courthouses will allow people to mail it in as well. And then there's also, even if someone were to e-file it or mail it in, there might be a hearing scheduled, and then at that point, someone would have to attend the hearing. So it depends.
I'm not sure if you can answer this, but can expunction records be sealed once they've been approved?
Expunction and sealing are two different things, and North Carolina, besides for like juvenile records, doesn't really have a sealing process. The expunction, if granted, means that case, that court file is destroyed in the court system. So I don't know if that was really an answer, but those are kind of two separate things. But if someone had a granted expunction, then there would be no real need to seal it because it would have been the public record would have been destroyed.
For automatic outcomes that qualify for automatic expunction, is it true, and I'm just reading this verbatim, is it true
Sure.
that the clerk is not required to give notice to government entities listed in the statute? Don't know if you know how to respond to that.
Yeah, I don't know if I can answer that question. What I will say is that really the issue that I have seen is that the petitioner, the person themselves who had the dismissed charge, they often do not receive any kind of notice that the charge was in fact expunged. But there is a form on the NC Court's website that is called the verification of prior record expunction, which is a form that someone can submit on their own behalf to request from the administrative office of the courts verification that a charge was in fact expunged. And so that is an option, but I don't know if I can answer that specific question.
Gotcha. Here's another one. I don't know if you can answer. My apologies.
Sure, no worries.
After a conviction has been expunged, say it was a conviction that prevented someone from being able to maybe own a firearm, if something gets expunged, are those rights been reinstated? Don't know if you
That
can
is
answer
not
this form.
that makes total sense, but that is not a question I can answer.
Perfect. Okay. Let's see. We've answered that one. Can you just review about the assault?
Yes.
Yeah, that part.
Yeah, absolutely. So essentially what that was kind of referring to is just in the law, the very first thing when it comes to looking at eligibility for adult convictions, there is a list of disqualifying convictions that essentially mean under the law, if somebody has a conviction for that type of offense, the law states they are not eligible to expunge any adult conviction. And I say adult because if somebody has qualifying youthful convictions, under the law, those still can be expunged. It's just the adult over 18 convictions that can't. And so, like I said, those are the most common ones. Assault, really, the statute just says if assault is an essential element of that offense, that type of offense is disqualifying. And the most obvious ones are the ones that have assault in the name. And so assault on a female, simple assault, assault with a deadly weapon, what we call alphabet assault, which is assault with a deadly weapon, serious injury, intent to kill, that kind of assault is also disqualifying. And so when it comes to assault, it's really just if assault is an essential element of that offense, then that is going to disqualify someone from expunging their adult convictions. Hopefully that helps clarify.
Is there, just in your experience, is there any way for someone to research their background like free of charge, like kind of do like a preliminary background check on themselves?
Yes, now I'm sure a lot of people are aware that there are plenty of third-party background check companies that arguably could have a criminal background record for somebody, but a lot of times those companies can use outdated data. And so what is available to the public, and is honestly what we use to do our search, is the 3 databases I mentioned earlier. All of those are public. And so there is the Department of Adult Corrections. They have a public criminal record database that isn't complete. What the Department of Adult Corrections records will show is any conviction where somebody served some kind of sentence, usually prison sentence or supervised probation. So if somebody served some type of supervised probation or actual active time, the DAC will show that on their database. Then you have the database that is phasing out, which is called Cypress. And then you also have the portal, which is the new database that the counties are slowly moving to. Both of those you can find terminals in, should be every single courthouse in the state, and that is free of charge. And so you can go in there and search your name, date of birth, other demographic information, and it should pull up statewide. It's only going to show North Carolina, but it should show statewide any criminal charges or convictions that that person may have. And that is free of charge. And those three databases are what we use to pull hopefully a comprehensive record that we can confirm with the client. Someone can also, someone can also request our own SBI, but that does come with a cost. And that's likely only going to show records that someone was fingerprinted for. So the difficult thing is there are options, just a lot of these options don't show, like, it usually takes more than one to get a comprehensive record, but there are options, yes.
On the petition where it says arresting agency, is that the agency that took out the warrant, or is it the actual, should you list the agency that took out the warrant or the agency that actually conducted the arrest, if those are two different agencies?
A lot of times that is going to be the agency that, arresting agency, aka the agency that, if somebody was arrested that person.
Perfect.
It can't hurt to put both. I'll say that too.
I think you just answered this. Someone just isn't sure about what happened in their case, like what the actual outcome was. Where would they go to figure out what that outcome of a case was?
You should be able to go to one of those public terminals in the local courthouse, wherever that person lives, and should be able to search that up, especially if someone has the case number. Should be able to search it up, and that should tell you what happened.
Is any conviction that took place while someone was a juvenile eligible for expunction? So regardless of what it was, can that be expunged?
No, it's going to depend on what type of offense, because it is most misdemeanors and some class HRIs. And so there are still requirements and restrictions, just like for adult convictions, on the types of youthful convictions that are eligible. So it's not any conviction that occurred when someone was 16 or 17. It's going to depend on what it was.
And then last thing here, someone mentioned, and I think you already alluded, that they've been having some issues trying to get to legal aid through the phone line.
Yes.
Can they apply for expunction services online, or do they need to keep trying with the helpline?
Unfortunately, we do not have the ability to have online applications. That is mainly just because there is such a need. And so just to make it manageable for us, we have limited it to the phone line, and I acknowledge that we are having issues, and so I appreciate the patience. I know that we're speaking with the network to try to get those sorted out. And so I would just encourage you, if you're able to keep trying, and then if you're not able to get through, then I would definitely encourage you to try back in July from the 7th to the 11th.
Let me just do one last check. I am not seeing any other questions here, so I'm going to go ahead and say thank you to everyone. Oh, wait. Spoke too soon. Someone's asking if dismissed pursuant to a deferred prosecution or conditional discharge, are those treated as the same as dismissals for expunction purposes, or no?
They are treated the same, as in that they were ultimately dismissed, and so they are eligible. The difference would be that there would be a filing fee associated with that petition because of the conditional discharge and the deferred prosecution. And so it's still eligible. There just might be that filing fee associated.
Perfect. Okay. And now I'm going to say thank you to everyone for joining us, with a special thank you to Lorena for presenting and for answering all of those questions for us. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other listen and learns, like Lorena mentioned, such as child custody, tenant rights, simple divorce, Medicaid, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their afternoon.
Thank you.